Article 901. When the testator dies leaving illegitimate children and no other compulsory heirs, such illegitimate children shall have a right to one half of the hereditary estate of the deceased. The other half shall be at the free disposal of the testator. 842a. Article 902. The rights of illegitimate children set forth in the preceding articles are transmitted upon their death to their descendants, whether legitimate or illegitimate. 843a. Article 903. The legitimacy of the parents who have an illegitimate child. When such child leaves neither legitimate descendants, nor a surviving spouse, nor illegitimate children, is one half of the hereditary estate of such illegitimate child. If only legitimate or illegitimate children are left, the parents are not entitled to any legitimacy whatsoever. If only the widow or widower survives with parents of the illegitimate child, the legitimacy of the parents is 1/4 of the hereditary estate of the child, and that of the surviving spouse also 1/4 of the estate. N. Article 904. The testator cannot deprive his compulsory heirs of their legitimacy, except in cases expressly specified by law. Neither can he impose upon the same any burden, encumbrance, condition, or substitution of any kind whatsoever. 813a. Article 905. Every renunciation or compromise as regards a future legitimacy between the person owing it and his compulsory heirs is void, and the latter may claim the same upon the death of the former. But they must bring to collation whatever they may have received by virtue of the renunciation or compromise. 816. Article 906. Any compulsory heir to whom the testator has left by any title less than the legitimacy belonging to him may demand that the same be fully satisfied. 815. Article 907. Testamentary dispositions that impair or diminish the legitimacy of the compulsory heirs shall be reduced on petition of the same, insofar as they may be inefficacious or excessive. 817. Article 908. To determine the legitimacy, the value of the property left at the death of the testator shall be considered, deducting all debts and charges, which shall not include those imposed in the will. To the net value of the hereditary estate shall be added the value of all donations by the testator that are subject to collation at the time he made them. 818a. Article 909. Donations given to children shall be charged to their legitimacy. Donations made to strangers shall be charged to that part of the estate of which the testator could have disposed by his last will, insofar as they may be inefficacious or may exceed the disposable portion. They shall be reduced according to the rules established by this code. 819a. Article 910. Donations which an illegitimate child may have received during the lifetime of his father or mother, shall be charged to his legitimacy. Should they exceed the portion that can be freely disposed of, they shall be reduced in the manner prescribed by this code. 847a. Article 911. After the legitimacy has been determined in accordance with the three preceding articles, the reduction shall be made as follows. 1. Donations shall be respected as long as the legitimacy can be covered, reducing or annulling, if necessary, the devises or legacies made in the will. 2. The reduction of the devises or legacies shall be pro rata, without any distinction whatever. If the testator has directed that a certain devise or legacy be paid in preference to others, it shall not suffer any reduction until the latter have been applied in full to the payment of the legitimacy. 3. If the devise or legacy consists of a usufruct or life annuity, whose value may be considered greater than that of the disposable portion, the compulsory heirs may choose between complying with the testamentary provision in delivering to the devotee her legatee the part of the inheritance of which the testator could freely dispose. 820a. Article 912. If the devise subject to reduction should consist of real property, which cannot be conveniently divided, it shall go to the devotee if the reduction does not absorb one half of its value, and in a contrary case, to the compulsory heirs, but the former and the latter shall reimburse each other in cash for what respectively belongs to them. The devotee who is entitled to a legitimate may retain the entire property, provided its value does not exceed that of the disposable portion and of the share pertaining to him as legitimate. 821. Article 913. If the heirs or devisees do not choose to avail themselves of the right granted by the preceding article, any heir or devotee who did not have such right may exercise it, should the latter not make use of it. The property shall be sold at public auction, at the instance of any one of the interested parties. 822. Article 914. The testator may devise and bequeath the free portion as he may deem fit. N. Section 6. Disinheritance. Article 915. A compulsory heir may, in consequence of disinheritance, be deprived of his legitimate, for causes expressly stated by law. 848a. Article 916. Disinheritance can be effected only through a will wherein the legal cause therefore shall be specified. 849. Article 917. The burden of proving the truth of the cause for disinheritance shall rest upon the other heirs of the testator, if the disinherited heir should deny it. 850. Article 918. Disinheritance without a specification of the cause, or for a cause the truth of which, if contradicted, is not proved, or which is not one of those set forth in this code, shall annul the institution of heirs insofar as it may prejudice the person disinherited. But the devises and legacies and other testamentary dispositions shall be valid to such extent as will not impair the legitimacy. 851a. Article 919. The following shall be sufficient causes for the disinheritance of children and descendants, legitimate as well as illegitimate. 1. When a child or descendant has been found guilty of an attempt against the life of the testator, his or her spouse, descendants, or ascendants. 2. When a child or descendant has accused the testator of a crime for which the law prescribes imprisonment for 6 years or more, if the accusation has been found groundless. 3. When a child or descendant has been convicted of adultery or concubinage with the spouse of the testator. 4. When a child or descendant by fraud, violence, intimidation, or undue influence causes the testator to make a will or to change one already made. 5. A refusal without justifiable cause to support the parent or ascendant who disinherits such child or descendant. 6. Maltreatment of the testator by word or deed, by the child or descendant. 7. When a child or descendant leads a dishonorable or disgraceful life. 8. Conviction of a crime which carries with it the penalty of civil interdiction. 756, 853, 674a. Article 920. The following shall be sufficient causes for the disinheritance of parents or ascendants, whether legitimate or illegitimate. 1. When the parents have abandoned their children or induced their daughters to live a corrupt or immoral life, or attempted against their virtue. 2. When the parent or ascendant has been convicted of an attempt against the life of the testator, his or her spouse, descendants, or ascendants. 3. When the parent or ascendant has accused the testator of a crime for which the law prescribes imprisonment for 6 years or more, if the accusation has been found to be false. 4. When the parent or ascendant has been convicted of adultery or concubinage with the spouse of the testator. 5. When the parent or ascendant by fraud, violence, intimidation, or undue influence causes the testator to make a will, or to change one already made. 6. The loss of parental authority for causes specified in this code. 7. The refusal to support the children or descendants without justifiable cause. 8. An attempt by one of the parents against the life of the other, unless there has been a reconciliation between them. 756, 854, 674a. Article 921. The following shall be sufficient causes for disinheriting a spouse. 1. When the spouse has been convicted of an attempt against the life of the testator, his or her descendants, or ascendants. 2. When the spouse has accused the testator of a crime for which the law prescribes imprisonment of 6 years or more, and the accusation has been found to be false. 3. When the spouse by fraud, violence, intimidation, or undue influence caused the testator to make a will or to change one already made. 4. When the spouse has given cause for legal separation. 5. When the spouse has given grounds for the loss of parental authority. 6. Unjustifiable refusal to support the children or the other spouse. 756, 855, 674a. Article 922. A subsequent reconciliation between the offender and the offended person deprives the latter of the right to disinherit, and renders ineffectual any disinheritance that may have been made. 856. Article 923. The children and descendants of the person disinherited shall take his or her place and shall preserve the rights of compulsory heirs with respect to the legitimate. But the disinherited parent shall not have the usufruct or administration of the property which constitutes the legitimate. 857. Section 7. Legacies and devises. Article 924. All things and rights which are within the commerce of man be bequeathed or devised. 865a. Article 925. A testator may charge with legacies and devises not only his compulsory heirs but also the legatees and devisees. The latter shall be liable for the charge only to the extent of the value of the legacy or the devise received by them. The compulsory heirs shall not be liable for the charge beyond the amount of the free portion given them. 858a. Article 926. When the testator charges one of the heirs with a legacy or devise, he alone shall be bound. Should he not charge anyone in particular, all shall be liable in the same proportion in which they may inherit. 859. Article 927. If two or more heirs take possession of the estate, they shall be solidarily liable for the loss or destruction of a thing devised or bequeathed, even though only one of them should have been negligent. N. Article 928. The heir who is bound to deliver the legacy or devise shall be liable in case of eviction, if the thing is indeterminate and is indicated only by its kind. 860. Article 929. If the testator, heir, or legatee owns only a part of, or an interest in the thing bequeathed, the legacy or devise shall be understood limited to such part, or interest, unless the testator expressly declares that he gives the thing in its entirety. 864a. Article 930. The legacy or devise of a thing belonging to another person is void if the testator erroneously believed that the thing pertained to him, but if the thing bequeathed, though not belonging to the testator when he made the will, afterwards becomes his, by whatever title, the disposition shall take effect. 862a. Article 931. If the testator orders that a thing belonging to another be acquired in order that it be given to a legatee or devotee, the heir upon whom the obligation is imposed or the estate must acquire it and give the same to the legatee or devotee, but if the owner of the thing refuses to alienate the same, or demands an excessive price therefore, the heir of the estate shall only be obliged to give the just value of the thing. 861a. Article 932. The legacy or devise of a thing which at the time of the execution of the will already belonged to the legatee or devotee shall be ineffective, even though another person may have some interest therein, if the testator expressly orders that the thing be freed from such interest or encumbrance. The legacy or devise shall be valid to that extent. 866a. Article 933. If the thing bequeathed belonged to the legatee or devotee at the time of the execution of the will, the legacy or devise shall be without effect, even though it may have subsequently alienated by him. If the legatee or devotee acquires it gratuitously after such time, he can claim nothing by virtue of the legacy or devise, but if it has been acquired by onerous title, he can demand reimbursement from the heir of the estate. 878a. Article 934. If the testator should bequeath or devise something pledged or mortgaged to secure a recoverable debt before the execution of the will, the estate is obliged to pay the debt, unless the contrary intention appears. The same rule applies when the thing is pledged or mortgaged after the execution of the will. Any other charge, perpetual or temporary, with which the thing bequeathed is burdened, passes with it to the legatee or devotee. 867a. Article 935. The legacy of a credit against a third person or of the remission or release of a debt of the legatee shall be effective only as regards that part of the credit or debt existing at the time of the death of the testator. In the first case, the estate shall comply with the legacy by assigning to the legatee all rights of action it may have against the debtor. In the second case, by giving the legatee an acquittance, should he request one. In both cases, the legacy shall comprise all interests on the credit or debt which may be due the testator at the time of his death. 870a. Article 936. The legacy referred to in the preceding article shall lapse if the testator, after having made it, should bring an action against the debtor for the payment of his debt, even if such payment should not have been effected at the time of his death. The legacy to the debtor of the thing pledged by him is understood to discharge only the right of pledge. 871. Article 937. A generic legacy of release or remission of debts comprises those existing at the time of the execution of the will, but not subsequent ones. 872. Article 938. A legacy or devise made to a creditor shall not be applied to his credit, unless the testator so expressly declares. In the latter case, the creditor shall have the right to collect the excess, if any, of the credit or of the legacy or devise. 837a. Article 939. If the testator orders the payment of what he believes he owes but does not in fact owe, the disposition shall be considered as not written. If his regards a specified debt more than the amount thereof is ordered paid, the excess is not due, unless a contrary intention appears. The foregoing provisions are without prejudice to the fulfillment of natural obligations. N. Article 940. In alternative legacies or devises, the choice is presumed to be left to the heir upon whom the obligation to give the legacy or devise may be imposed, or the executor or administrator of the estate if no particular heir is so obliged. If the heir, legatee or devotee, who may have been given the choice, dies before making it, This right shall pass to the respective heirs. Once made, the choice is irrevocable. In the alternative, legacies or devises, except as herein provided. The provisions of this code regulating obligations of the same kind shall be observed, save such modifications as may appear from the intention expressed by the testator. 874a. Article 941. A legacy of generic personal property shall be valid even if there be no things of the same kind in the estate. A devise of indeterminate, real property shall be valid only if there be a movable property of its kind in the estate. The right of choice shall belong to the executor or administrator who shall comply with the legacy by the delivery of a thing which is neither of inferior nor of superior quality. 875a. Article 942. Whenever the testator expressly leaves the right of choice to the heir, or to the legatee or devotee, the former may give, or the latter may choose whichever he may prefer. 876a. Article 943. If the heir, legatee or devotee cannot make the choice, in case it has been granted him, his right shall pass to his heirs. But a choice once made shall be irrevocable. 877a. Article 944. A legacy for education lasts until the legatee is of age, or beyond the age of majority, in order that the legatee may finish some professional, vocational or general course, provided he pursues his course diligently. A legacy for support lasts during the lifetime of the legatee, if the testator has not otherwise provided. If the testator has not fixed the amount of such legacies, it shall be fixed in accordance with the social standing and the circumstances of the legatee and the value of the estate. If the testator or during his lifetime used to give the legatee a certain sum of money or other things by way of support, the same amount shall be deemed bequeathed, unless it be markedly disproportionate to the value of the estate. 879a. Article 945. If a periodical pension, or a certain annual, monthly, or weekly amount is bequeathed, the legatee may petition the court for the first installment upon the death of the testator, and for the following ones, which shall be due at the beginning of each period. Such payment shall not be returned, even though the legatee should die before the expiration of the period which has commenced. 880a. Article 946. If the thing bequeathed should be subject to a usufruct, the legatee or devotee shall respect such right until it is legally extinguished. 868a. Article 947. The legatee or devotee acquires a right to the pure and simple legacies or devises from the death of the testator, and transmits it to his heirs. 881a. Article 948. If the legacy or devise is of a specific and determinate thing pertaining to the testator, the legatee or devotee acquires the ownership thereof upon the death of the testator, as well as any growing fruits, or unborn offspring of animals, or uncollected income, but not the income which was due and unpaid before the latter's death. From the moment of the testator's death, the thing bequeathed shall be at the risk of the legatee or devotee, who shall, therefore, bear its loss or deterioration, and shall be benefited by its increase or improvement, without prejudice to the responsibility of the executor or administrator. 882a. Article 949. If the bequest should not be of a specific and determinate thing, but is generic or of quantity, its fruits and interests, from the time of the death of the testator shall pertain to the legatee or devotee if the testator has expressly so ordered. 884a. Article 950. If the estate should not be sufficient to cover all the legacies or devises, their payment shall be made in the following order. 1. Remuneratory legacies or devises. 2. Legacies or devises declared by the testator to be preferential. 3. Legacies for support. 4. Legacies for education. 5. Legacies or devises of a specific, determinate thing which forms a part of the estate. 6. All others pro rata. 887a. Article 951. The thing bequeathed shall be delivered with all its accessories, and in the condition in which it may be, upon the death of the testator. 883a. Article 952. The heir charged with a legacy or devise, or the executor or administrator of the estate, must deliver the very thing bequeathed if he is able to do so and cannot discharge this obligation by paying its value. Legacies of money must be paid in cash, even though the heir of the estate may not have any. The expenses necessary for the delivery of the thing bequeathed shall be for the account of the heir of the estate, but without prejudice to the legitimate. 886a. Article 953. The legatee or devizee cannot take possession of the thing bequeathed upon his own authority, but shall request its delivery and possession of the heir charged with the legacy or devise, or of the executor or administrator of the estate should he be authorized by the court to deliver it. 885a. Article 954. The legatee or devizee cannot accept a part of the legacy or devise and repudiate the other, if the latter be onerous. Should he die before having accepted the legacy or devise, leaving several heirs, some of the latter may accept and the others may repudiate the share respectively belonging to them in the legacy or devise. 889a. Article 955. The legatee or devizee of two legacies or devises, one of which is onerous, cannot renounce the onerous one and accept the other. If both are onerous or gratuitous, he shall be free to accept or renounce both, or to renounce either. But if the testator intended that the two legacies or devises should be inseparable from each other, the legatee or devizee must either accept or renounce both. Any compulsory heir who is at the same time a legatee or devizee may waive the inheritance and accept the legacy or devise, or renounce the latter and accept the former, or waive or accept both. 890a. Article 956. If the legatee or devizee cannot or is unwilling to accept the legacy or devise, or if the legacy or devise for any reason should become ineffective, it shall be merged into the mass of the estate, except in cases of substitution and of the right of accretion. 888a. Article 957. The legacy or devise shall be without effect. 1. If the testator transforms the thing bequeathed in such a manner that it does not retain either the form or the denomination it had. 2. If the testator by any title or for any cause alienates the thing bequeathed or any part thereof, it being understood that in the latter case the legacy or devise shall be without effect only with respect to the part thus alienated. If after the alienation the thing should again belong to the testator, even if it be by reason of nullity of the contract, the legacy or devise shall not thereafter be valid, unless the reacquisition shall have been effected by virtue of the exercise of the right of repurchase. 3. If the thing bequeathed is totally lost during the lifetime of the testator, or after his death without the heir's fault, nevertheless, the person obliged to pay the legacy or devise shall be liable for eviction if the thing bequeathed should not have been determinate as to its kind, in accordance with the provisions of Article 928. 869a. Article 958. A mistake as to the name of the thing bequeathed or devised is of no consequence, if it is possible to identify the thing which the testator intended to bequeath or devise. N. Article 959. A disposition made in general terms in favor of the testator's relatives shall be understood to be in favor of those nearest in degree. 751. Chapter 3. Legal or intestate succession. Section 1. General provisions. Article 960. Legal or intestate succession takes place 1. If a person dies without a will, or with a void will, or one which has subsequently lost its validity. 2. When the will does not institute an heir to, or dispose of all the property belonging to the testator. In such case, legal succession shall take place only with respect to the property of which the testator has not disposed. 3. If the suspensive condition attached to the institution of heir does not happen or is not fulfilled, or if the heir dies before the testator, or repudiates the inheritance, there being no substitution, and no right of accretion takes place. 4. When the heir instituted is incapable of succeeding, except in cases provided in this Code. 912a. Article 961. In default of testamentary heirs, the law vests the inheritance in accordance with the rules hereinafter set forth in the legitimate and illegitimate relatives of the deceased, in the surviving spouse, and in the state. 913a. Article 962. In every inheritance, the relative nearest in degree excludes the more distant ones, saving the right of representation when it properly takes place. Relatives in the same degree shall inherit in equal shares, subject to the provisions of Article 1006 with respect to relatives of the full and half-blood, and of Article 987, paragraph 2, concerning division between the paternal and maternal lines. 912a. Subsection 1. Relationship. Article 963. Proximity of relationship is determined by the number of generations. Each generation forms a degree. 915. Article 964. A series of degrees forms a line, which may be either direct or collateral. A direct line is that constituted by the series of degrees among ascendants and descendants. A collateral line is that constituted by the series of degrees among persons who are not ascendants and descendants, but who come from a common ancestor. 916a. Article 965. The direct line is either descending or ascending. The former unites the head of the family with those who descend from him. The latter binds a person with those from whom he descends. 917. Article 966. In the line, as many degrees are counted as there are generations or persons, excluding the progenitor. In the direct line, ascent is made to the common ancestor. Thus, the child is 1 degree removed from the parent, 2 from the grandfather, and 3 from the great-grandparent. In the collateral line, ascent is made to the common ancestor and then descent is made to the person with whom the computation is to be made. Thus, a person is 2 degrees removed from his brother, 3 from his uncle, who is the brother of his father, 4 from his first cousin, and so forth. 918a. Article 967. Full-blood relationship is that existing between persons who have the same father and the same mother. Half-blood relationship is that existing between persons who have the same father, but not the same mother, or the same mother, but not the same father. 920a. Article 968. If there are several relatives of the same degree, and one or some of them are unwilling or incapacitated to succeed, his portion shall accrue to the others of the same degree, save the right of representation when it should take place. 922. Article 969. If the inheritance should be repudiated by the nearest relative, should there be one only, or by all the nearest relatives, called by law to succeed, should there be several. Those of the following degree shall inherit in their own right and cannot represent the person or persons repudiating the inheritance. 923. Subsection 2. Right of representation. Article 970. Representation is a right created by fiction of law, by virtue of which the representative is raised to the place and the degree of the person represented, and acquires the rights which the latter would have if he were living or if he could have inherited. 942a. Article 971. The representative is called to the succession by the law and not by the person represented. The representative does not succeed the person represented but the one whom the person represented would have succeeded. N. Article 972. The right of representation takes place in the direct descending line, but never in the ascending. In the collateral line, it takes place only in favor of the children of brothers or sisters, whether they be of the full or half-blood. 925. Article 973. In order that representation may take place, it is necessary that the representative himself be capable of succeeding the decedent. N. Article 974. Whenever there is succession by representation, the division of the estate shall be made per stirps, in such manner that the representative or representatives shall not inherit more than what the person they represent would inherit, if he were living, or could inherit. 926a. Article 975. When children of one or more brothers or sisters of the deceased survive, they shall inherit from the latter by representation, if they survive with their uncles or aunts. But if they alone survive, they shall inherit in equal portions. 927. Article 976. A person may represent him whose inheritance he has renounced. 928a. Article 977. Heirs who repudiate their share may not be represented. 929a. Section 2. Order of intestate succession. Subsection 1. Descending direct line. Article 978. Succession pertains, in the first place, to the descending direct line. 930. Article 979. Legitimate children and their descendants succeed the parents and other ascendants, without distinction as to sex or age, and even if they should come from different marriages. An adopted child succeeds to the property of the adopting parents in the same manner as a legitimate child. 931a. Article 980. The children of the deceased shall always inherit from him in their own right, dividing the inheritance in equal shares. 932. Article 981. Should children of the deceased and descendants of other children who are dead survive, the former shall inherit in their own right, and the latter by right of representation. 934a. Article 982. The grandchildren and other descendants shall inherit by right of representation, and if any one of them should have died, leaving several heirs, the portion pertaining to him shall be divided among the latter in equal portions. 933. Article 983. If illegitimate children survive with legitimate children, the shares of the former shall be in the proportions prescribed by Article 895. N. Article 984. In case of the death of an adopted child, leaving no children or descendants, his parents and relatives by consanguinity and not by adoption, shall be his legal heirs. N. Subsection 2. Ascending direct line. Article 985. In default of legitimate children and descendants of the deceased, his parents and descendants shall inherit from him, to the exclusion of collateral relatives. 935a. Article 986. The father and mother, if living, shall inherit in equal shares. Should one only of them survive, he or she shall succeed to the entire estate of the child. 936. Article 987. In default of the father and mother, the ascendants nearest in degree shall inherit. Should there be more than one of equal degree belonging to the same line, they shall divide the inheritance per capita. Should they be of different lines but of equal degree, one half shall go to the paternal and the other half to the maternal ascendants. In each line, the division shall be made per capita. 937. Subsection 3. Illegitimate children. Article 988. In the absence of legitimate descendants or ascendants, the illegitimate children shall succeed to the entire estate of the deceased. 939a. Article 989. If, together with illegitimate children, there should survive descendants of another illegitimate child who is dead, the former shall succeed in their own right and the latter by right of representation. 940a. Article 990. The hereditary rights granted by the two preceding articles to illegitimate children shall be transmitted upon their death to their descendants, who shall inherit by right of representation from their deceased grandparent. 941a. Article 991. If legitimate ascendants are left, the illegitimate children shall divide the inheritance with them, taking one half of the estate, whatever be the number of the ascendants or of the illegitimate children. 942, 841a. Article 992. An illegitimate child has no right to inherit ab intestito from the legitimate children and relatives of his father or mother, nor shall such children or relatives inherit in the same manner from the illegitimate child. 943a. Article 993. If an illegitimate child should die without issue, either legitimate or illegitimate, his father or mother shall succeed to his entire estate, and if the child's filiation is duly proved as to both parents, who are both living, they shall inherit from him share and share alike. 944a. Article 994. In default of the father or mother, an illegitimate child shall be succeeded by his or her surviving spouse, who shall be entitled to the entire estate. If the widow or widower should survive with brothers and sisters, nephews and nieces, she or he shall inherit one half of the estate, and the latter the other half. 945a. Subsection 4. Surviving spouse. Article 995. In the absence of legitimate descendants and ascendants, and illegitimate children and their descendants, whether legitimate or illegitimate, the surviving spouse shall inherit the entire estate, without prejudice to the rights of brothers and sisters, nephews and nieces, should there be any, under Article 1001. 946a. Article 996. If a widow or widower and legitimate children or descendants are left, the surviving spouse has in the succession the same share as that of each of the children. 834a. Article 997. When the widow or widower survives with legitimate parents or ascendants, the surviving spouse shall be entitled to one half of the estate, and the legitimate parents or ascendants to the other half. 836a. Article 998. If a widow or widower survives with illegitimate children, such widow or widower shall be entitled to one half of the inheritance, and the illegitimate children are their descendants, whether legitimate or illegitimate, to the other half. N. Article 999. When the widow or widower survives with legitimate children are their descendants, and illegitimate children are their descendants, whether legitimate or illegitimate. Such widow or widower shall be entitled to the same share as that of a legitimate child. N. Article 1000. If legitimate ascendants, the surviving spouse, and illegitimate children are left, the ascendants shall be entitled to one half of the inheritance, and the other half shall be divided between the surviving spouse and the illegitimate children, so that such widow or widower shall have 1/4 of the estate, and the illegitimate children the other fourth.